Representative Baram.
Thank you, Mr. Chairman. I also want to add my endorsement of this bill. I think it's a great step forward. I think it only answers part of the question, however, because the other side of the issue are the resources that we allocate to the courts. For those of you who may include in your practices of law family, you know how difficult it is when you go to court. Your clients are apprehensive to begin with. You get to a court for the call at 9 a.m., and maybe your case isn't heard, or you're not assigned to a family relations officer until noon, 1 o'clock, 2 o'clock. And in the meantime, as an attorney, you're charging your client while you're there. There's no call-in system. There's no scheduling for the court to avoid the lengthy wait. For those of you who haven't been to a courthouse on a busy day, you can have hundreds of people herding around in the hallways with no rooms to sit, no way to sit down and have a civil conversation. Attorneys are going back and forth between benches in the court hallway where everybody's watching and talking and listening. It's not a conducive situation. Many of us have advocated family law centers, court centers that would have one-stop shopping where you'd have your family relations, you'd have a dedicated judicial system with judges who are more experienced in family law and other resources there. I know that when judicial liaisons come before our committee, I always ask, how do you assign judges? How do you assign your resources? Because it seems to me that our family courts are breaking at the seams. There's not enough judges. There's not enough family relations officers. And when I look on the criminal side with all the diversionary programs and resources that exist, I don't see those same resources on the family side. So that's part of the problem. People are coming to court hyped up, ready for a contentious battle. And I'll say, there's always two sides to a coin. Undoubtedly, the people we heard from yesterday have legitimate grievances, but we don't know the particulars of their case. I mean, I've had child custody cases, visitation cases, where I'm sure the parent on the other side said, I got cheated. The court didn't hear what I had to say. But again, we're not privy to all the information. But nevertheless, the system is breaking down, and there needs to be a revitalization of it. And again, I thank the task force, this committee, Representative Gonzalez, for her passion in bringing this to our attention. A couple of very specific things on the bill. A number of my colleagues have pointed to line 5 with the notification of 5 persons. Actually, the way I'm reading this bill, if you jump to lines 18 through 24, it appears that the parties can come to a written agreement and ask for their own person as a guardian ad litem. So the way I'm reading this, and I'd like to ask through the chair if you have any insight into this, it's my understanding that the parties could request an entire list of who all the guardian ad litems are for that district, much like Representative O'Day said takes place for foreclosures, and decide after looking these people up and learning a little bit about them and perhaps their fee structures, come to an agreement and give that to the court before the court gives them a list of 5 people. So I think in reading subsection B in connection with A, that it's not automatic that the judge gives 5 people. If the parties want to see the whole list, that they should be entitled to it, come to an agreement, and if they can't, then the court would try and assist them by giving them a list of 5. And I'm wondering if that's your interpretation.
Thank you for the question. Yes, I think the parties would always be encouraged, and it would be welcomed by the court if they could reach agreement on who they want to serve as a guardian ad litem or attorney for the minor child.
Thank you for that. The last question I have, is found in lines 32 through 36. We were talking about the fees charged by those appointed guardian ad litem or counsel for the children. And in paragraph 4, it says, the fee schedule of such counsel or guardian ad litem shall be minimally set forth, and it talks about the amount of the retainer, the hourly rate to be charged. I'm wondering if the chair thinks that this suggests that there is going to be some fee schedule set by the court in terms of what attorneys or anybody appointed to this position can charge, or if it's just what the market bears, subject to the reasonableness as determined by the court.
Well, I would think the presence in the bill of a creation of a sliding scale would indicate that the fees that are charged would be appropriate with the income of the parties that are before the court. So I think that's your question.
Not really. I do understand, because the judges do it now, quite frankly, is they will assign the party who has the resources to pay more than the other spouse will assign, a proportion of the fee, and I understand that's probably the sliding scale. It's to determine who can pay what. But I'm talking about the actual hourly charge of the attorney. Will it be that the judges will publish the hourly rates of the attorneys so that you can determine what they are, or will they say no attorney can charge, let's say, more than $200 an hour? I'm just trying to understand this part of it that says the fee schedule shall be set forth. I'm not asking a question about how much the clients will pay or the parties will pay. I'm asking, is there any cap or oversight on what the attorneys can charge to begin with?
I think that there would be, that it would pursuant to their respective income. So I think it would, if they make, as in the example earlier, $50,000 as a family, then they would fall under a certain level of fee and or an hourly rate, let's say, for example. And then at that point, the court would say, okay, who has the capacity to pay, and then they would apportion the percentage.
So what if there was an attorney whose hourly rate was, we'll say, $400 an hour, and another attorney who was willing to charge $200? Both of those individuals would be on the list then. They would acknowledge what their rates were, and I guess hopefully the parties would pick the one that they thought was competent, first of all, and that they could afford, secondly.
Yes, I would think they would pick the one that they can afford, and I think the court would look to which one they can afford. And I think, as you know, and as the others here know, that the quality of the service does not necessarily depend upon the hourly rate. But I think the parties should be able to select who they can afford and who falls within their income parameters.
Well, thank you for that clarification, and I would hope that when the court publishes this list, that they might ask those who are on it to give them what their hourly fees are, so that can be part of the information used by the parties in deciding, just as one factor to decide who they wish to choose.
Yeah, and I mean, just if I may go one step further, I mean, I think the court's going to have some idea as to the hourly rate for the respective guardians ad litem or attorneys, because it wouldn't make any sense to, if they were in a situation where they had to recommend somebody, it wouldn't make any sense to recommend 5 names that are not within the income range of the people.
Thank you very much.